Good morning, friends. Today I will take you through the extended period of limitation which is still available for certain applications for filing opposition against these trademark applications. Recently, 4 writ petitions were filed before Delhi High Court against the CGPDTM for denying them an opportunity for filing the oppositions against the trademark application after expiry of 4 months, but they fall within the extended period of limitation. In view of these submissions by the petitioner, the officials representing the CGPDTM, they acknowledge that yes, the CGPDTM has issued public notices acknowledging the limitation orders as well as the extended period of limitation in 19th of June 2020 as well as later on the 18th of January 2022. Moreover, the CGPDTM has entertained approximately 1 lakh opposition applications as well as issued 4.87 trademark certificates during the 24th of March 2020 to 28th of February 2022. At no point of time, the officials representing the CGPDTM made submission that various opposition applications were entertained even after the expiry of the 4 months during this period. So when court put a specific query to these officials on how many oppositions were filed after the expiry of 4 months, then it came to the notice of the court that around 6,000 to 7,000 opposition applications were entertained. Had this information been given to the court on the early stages of hearing, the court would have easily disposed of these petitions by giving appropriate relief to the petitioners. So, in view of this deliberate conduct of the officials, the court has imposed a heavy cost of 1 lakh rupees to each of the officials representing the CGPDTM before the Delhi High Court. In addition to this, this very proceedings highlights the arbitrariness in the decision making process at the CGPDTM. So now if we look at the scenario, their opposition applications were not at all allowed, whereas under the similar circumstances the CGPDTM has allowed 6,000 to 7,000 opposition applications, and the officials never made any submission on why these opposition applications were denied. Anyways, the court corrected this arbitrary decision making process and laid down few guidelines for the future period, at least till the expiry of 30th of May 2022. One important aspect for the IPR practitioners is that now the cutoff date for filing the opposition against these trademark applications for which the limitation has expired between 15th of March 2020 till 28th of February 2022 is 30th of May 2022. So till that, you still have an opportunity to oppose an advertised trademark for which the limitation period has expired in these 2 dates. Second is that if you wish to file any opposition and finds any difficulty in filing the opposition, you can send an email to the CGPDTM, and CGPDTM officials will ensure that the opposition application is adequately entertained by the officials. Either it could be through offline or it could be through online mode. Now coming to the question of certificates which has already been issued between these 2 dates. So what will happen to these certificates? So the court has laid down mechanism for handling this situation for each of these scenarios. First scenario could be the certificates were issued and there was no opposition filed against these trademark applications till 30th of May 2022. So in that case, these certificates will remain valid and applicant can enjoy its rights as per the law. Second scenario is where the certificate has been issued, but either the opposition has already been filed, or the registry may receive the opposition up to the time period of 30th of May 2022. So in such scenario, the certificate remains suspended till the disposal of the opposition application. So if the opposition proceedings goes in favor of the trademark applicant, then the certificate will be reinstated. Otherwise, if it goes in the favor of the opponent, obviously the trademark application stands rejected. The third scenario would be where the trademark applications were advertised and the limitation period for these applications falls within these two dates, March 2022, February 2022, and the certificates were not issued to the applicants. In such case, the direction is that the registry should wait till expiry of the 30th of May 2022. So the certificates will be issued only after that, provided there is no opposition filed for these applications also. In addition to this, the Delhi High Court also took cognizance of pending around 2 lakh opposition applications with the CGPDTM. So the High Court has ordered the CGPDTM to come out with a plan how they are going to address these long list of pending opposition applications. So hopefully, while reviewing this status for these guidelines, the High Court may come out with few more guidelines in regard to the dependency of 2 lakh opposition proceedings. But in any way, such kind of rulings are definitely going to bring transparency as well as the confidence amongst the IP stakeholders, which is good for IP practice in India. Hope this information is quite helpful for you, and I will try to bring more such practical insights from the court rulings. Till then, be safe and let's meet soon. Thank you.